Welcome to the Indian Gaming Association's The New Normal webcast. My name is Lisa Johnson. I'm the conference manager for the Indian Gaming Trade Show and Convention. I'd like to share a few housekeeping tips before we get started. Everyone is muted by default except for our speakers. If you have any questions during the presentation, please type them into the questionnaire chat box and they'll be brought up at the end. Now, without further ado, I'd like to introduce Victor Rocha, conference chairman of the Indian Gaming Association.
Good morning, everyone. Welcome to The Normal, your go-to source for insightful discussions on the gaming industry and critical issues affecting Native American tribes across the United States. My name is Victor Rocha. I'm the conference chairman for the Indian Gaming Association. My co-host is Jason Giles, executive director of the Indian Gaming Association. Today's webinar, we're talking to our dear friend, legendary tribal game attorney Scott Crowell, about the recent decision by the SCOTUS to overturn the Chevron doctrine. And, being the one who gets to pick the subjects on this conference, on this webinar, this is one of those issues that's kind of arcane if you're not watching, but I think this has a potential to have implications for tribes, not just gaming tribes, but tribes across the country. And by the way, I'm recording from my living room. I've been having internet trouble. So if anything happens, I drop out and stuff like that. I apologize ahead of time. Jason, good morning. How are you doing?
Morning. How's it going? Doing well.
Scott, how are you doing, my friend? Welcome. Good to see you.
Good morning. Thanks for inviting me back. Yeah, I'm doing well this morning. Beautiful Sedona,
Jason,
Arizona.
Sedona, is that where you live, really?
It is, yeah.
Oh my gosh, I didn't know that. How lucky. They call Temecula the Sedona of Southern California, which is really nice for a resale value.
Right.
Scott, welcome again. Like I said, the doctrine's this arcane law that a lot of us don't even think about. What is the Chevron doctrine?
Well, in 1984, the Supreme Court issued a case where Chevron was a party. That's why everyone refers to it as the Chevron doctrine. It was a landmark decision at the time because what it said was that when a federal regulation is at an issue, generally in the context of an APA case, that deference will be given to the agency's interpretation of any ambiguity in the statute, such that the court will uphold the agency interpretation so long as it was reasonable, even if it's wrong or inconsistent with congressional intent. And as a result of that, in a lot of the cases that have come since, when you're in a position of challenging a federal action, Chevron doctrine, generally has worked against you. And when you're, supporting a federal action, it's worked in your favor. When this decision came down, it caught my curiosity to go back and do just kind of a general canvas. And there are more than 100 reported federal court cases where the Chevron doctrine has been at issue in a case involving federal Indian law. Frankly, it's a mixed bag. In about 2/3 of those cases, Chevron doctrine was used to argue against tribal interest. And in about 40% of those cases, it was used to help defend tribal interest. I'll get into the interplay of the Chevron doctrine and the Indian canons of construction later on. But, for the most part, although I find, anytime this Supreme Court's going to overturn long-term precedent, I'm very cautious and scared. But as it relates to this particular case, I really don't think it's going to have that much of a direct impact on federal Indian law. for a variety of reasons.
As I've been reading and researching it, it seems like you said, it seems like a mixed bag. There are times when it's been used against us, it's times that it's went to our benefit, and it seems, where I see the issues would be in land in a trust. I think upstream environmental issues and water and timber and the stuff that affect a lot of tribes. I think minerals is a big one where I expect to see the Pacific Foundation and those guys start coming after regulatory stuff like that. So I can see, as a non-lawyer, as a layman, it just seems kind of a mixed bag there. There's reasons to be excited that, okay, pull some of the bureaucrats out of the process, but then on the other side, you're at the mercy of the courts, as usual.
Yeah. Yeah, in large respects, we were at the mercy of the courts, to begin with. Chevron doctrine is only one issue that comes into play in the interpretation of federal statutes. And two things that did not change as a result of the Loper decision is, one is called Skidmore deference, and that's a federal doctrine that says the federal courts are to give respect to agency interpretation of statutes or ambiguities in statutes. It's a far lesser standard than Chevron deference, but it still makes the agency's interpretation relevant. And the other is in factual determinations. The deference to agency determinations of fact aren't altered by the Loper decision at all.
And so, Scott, moving forward as a practitioner, as a litigator, the criticism of getting rid of the Chevron defense is, from a practical standpoint, we have this huge bureaucracy that, we want to get things done in somewhat of a timely manner. Removing this Chevron defense is going to open up a lot more avenues for lawsuits or challenges to agency actions. Just in a general sense, from you as a litigator, it could be any issue, not just Indian issues, but any issue where a bureaucrat makes a final agency decision. How is that going to be challenged from now on? There's a lower standard at the courts. So, it's, what do you think the practical outlook of? The lawyer's going to be a lot happier that they have more cases now, maybe, or, from a legal practice standpoint, how is this going to change things?
Well, it will impact virtually every APA case, that has been filed, whether it involves an Indian law issue or not. The portion of the brief that practitioners will write as it relates to congressional intent, will now have to, take Chevron out of the arsenal, whether it's good or bad. And like I said, and I think both Justice Jackson and Justice Kagan, in their dissents, raised fear that there would be a flood of new lawsuits. I'm not sure. I have a lot of respect, probably more respect for those two than anyone else on the bench, but I'm not certain that that's going to pan out. I think the motivations for someone in the industry to challenge a regulation did not rise or fall on the Chevron doctrine. The Chevron doctrine only involves ambiguities in the statute itself. If it's statute's not ambiguous, Chevron doesn't apply. And then you still have the argument that the agency's interpretation was unreasonable under Chevron. So So, I think those that were going to sue are still going to sue, and
Okay.
those that are not going to sue, probably still are not going to sue. But we'll wait to see, because I do think that a lot of people, a lot of plaintiffs' lawyers out there probably will say, "Oh, now because of the Loper decision, you have a better chance of challenging it." But really, when it comes down to deference to agency bureaucrats, I think on factual matters they deserve a lot of deference, and their decisions do deserve Skidmore respect. But when it really comes down to arguing what did Congress intend when it drafted this language, I don't think the folks over at the Department of Justice or the solicitor's office are any better or worse equipped than the lawyers advocating, on the behalfs of the parties, in the litigation as to what Congress intended. One of the frustrations that I'm going to see, I mean, I'm kind of an old dog. This decision came down a year after I graduated from law school, and people at Congress have understood this to be the law, and so when they're putting a statute together, they had the belief that they could, that they didn't have to get that specific as to their intent, believing that the federal agencies were capable to kind of fill in the gaps, and so they worked on drafting legislation, with that understanding in mind. And now it turns out that that understanding was incorrect. So, I think this decision is also going to have, impact on the way, both the way legislation is, they're going to have to be more careful in the way they draft it. And it makes it all that much more important to create a record of congressional intent in the process of considering and passing federal legislation.
Yeah, I mean, Scott, it's so given that, if we look specifically at Indian country, what are some of the potential administrative determinations that you can see either a commercial gaming operator challenging right away, or a local government challenging right away, whether that's a land in the trust decision? Are those the type of actions? What about like even the new Department of Interior regulations that, just went final, but were pretty favorable to tribes in terms of, where the location of a server is and some from that aspect, is that kind of the thing that could be challenged in court now?
Well, absolutely. I mean, it could have been challenged before, but
right.
It's more vulnerable to be challenged now, particularly the new 151 regulations and the new Part 293 regulations. On one side, although those regulations are relatively new, although they're relatively pro-tribal, with the exception of the analysis on mobile sports wagering, which I'll get to in a moment, it really didn't provide anything new. In fact, the department was very clear in their promulgation of both sets of regulations that, that this is an updated codification of the practices that they'd been engaged in, for a number of years. So I don't know if Chevron deference would actually make a difference in the outcome of the challenges that that we had already expected to both sets of regulations. As it relates to sports betting, the discussion about affirmatively including mobile wagering in compacts, the discussion about the allocation of jurisdiction and the location of the server, those are things that are all relatively new, but now that we have the West Flagler decision out of the DC Circuit and have the Supreme Court denying review of that, the DC Circuit did not rely on Chevron deference in reaching the conclusion that it was lawful. It didn't find an ambiguity in the statute and the need for some deference. Now, if West Flagler had gone the other way, I was excited with the Part 293 regs because I think it would have provided tribes a second bite at the apple. And there, under Chevron, the question would have simply been not whether the Department of Interior got it right, but whether the Department of Interior's interpretation is reasonable, and that would have carried the day. But that's all hypothetical now. Although you might see that challenge come up in the pending Colorado litigation, for example, or subsequent litigation. I do want to comment before we lose too much time, is how important it is to look at Chevron in the context of the Indian canons of construction. I think that's one of the reasons why Loper does not have that much of a overwhelming immediate impact on Indian country, because in the DC Circuit and the 10th Circuit, Indian canon of construction was given greater weight than Chevron deference, and therefore, when you're looking at interpreting ambiguities in federal statutes as it relate to Indian country, all three Indian canons were very important, and so gave tribes pushback against somebody using Chevron against them. In the 9th Circuit, which still has the majority of more tribes in the 9th Circuit than any other single circuit, we had this crazy decision, Babbitt versus Williams versus Babbitt, where the 9th Circuit had said if Chevron deference and the Indian canons of construction diverged, that Chevron deference would trump the Indian canons. And one positive impact of this case is it basically diffuses or moots the Williams versus Babbitt, improves the tribe's position in any case filed on the 9th Circuit.
Oh, you're on mute, Victor. Victor, you're on mute.
Sorry, this phone's been going in and out. I dropped out, as you saw. Just for our viewers, what exactly is Loper Bright Enterprises versus Raimundo? That's the case in Alaska would deal with mineral rights, right?
Well, the actual underlying facts, if I recall them correctly, was whether a federal agency could require a camera to be placed on boats as it relates to federal fishery regulations. The underlying factual context really isn't that important. That was the vehicle in which SCOTUS used to hang its hat to outright overturn Chevron. There had been a number of cases over the last decade where various justices have questioned the correctness and the appropriateness of Chevron and attempted to pare it back. And I think a lot of practitioners expected Loper to result in more of an erosion of Chevron and not the outright overruling of Chevron, which is what Loper ultimately did.
Right. That's what they said was an overstep on government overreach by putting it on blah, blah, blah. And so that was the vehicle which took it to the Supreme Court.
Right.
Well, it was interesting. I saw, as I was putting Pachanga to bed last night, an article came out about having a tribal gaming hall in Alaska, and so I see these small decisions being made that have me concerned. And, one of the things that I've noticed as a layman and someone who's been involved in tribal gaming for 25 years through Pachanga.net is that, it wasn't until gaming came that we were really able to fight for ourselves and to shine the light into those dark corners and those ambiguities, which we challenge. And a lot of times, they've fallen our way and other times they haven't. There are times when you see tribes united and say, listen, don't take that case to court because it could have a bad ruling for all of us. So
right.
In that context, I've always seen, tribal gaming, again, I say, you get the justice you can afford in this country, and tribal gaming has given tribes the resources to fight these type of things. So is this going to be part of our new strategy? We're going to have more legal. We have to be, I know it's always been one of the stools of anything we do is, gosh, that looks nice. Call the lawyer. You know what I mean? What do they say? As someone who I have on speed dial. So how is this going to affect? Should our mentality change? Should our way of thinking change? In dealing with legal and
yeah, I mean, every lawyer in every APA case is going to have to change the analysis. We're going to go back to more of a traditional analysis of statutory interpretation. If is the language plain and clear? If yes, then that's your answer. If no, then you have to look at other factors, including Skidmore deference to the agency's interpretation, and application of other canons of construction, which is why I think the removal of Chevron deference actually breathes stronger life into the Indian canons of construction. And also regarding the relevance of the record of congressional intent at the time that the legislation was passed. All those things become stronger now, or more important now, because of the loss of Chevron deference. We're looking proactively. I think that as we're dealing with Congress and the passage of federal Indian legislation, it becomes more critical to try to be as clear and plain in the language as possible, and to develop that record of congressional intent at the time, with the idea that it'll be used later in courts as you figure out. The judge still basically has the same question in front of him of what did Congress intend when they adopted this specific language.
And Scott,
so Jason, go ahead, Jason.
Well, no, Scott, I want to, because Victor raises a good question. A bunch of the other litigators I've talked to who do Indian country cases, they, like you, they describe Chevron as more of a double-edged sword. It's good on the offense and the defense, but with it gone now, they hearkened back to maybe when you had an administration that wasn't so favorable to Indian policy. And I jokingly said, well, are you going to enjoy taking cases to the Eileen Cannons of the world and some of these more ideological judges?
He said Indian Cannon, not Arlene Cannon.
Oh, not Eileen. Okay. But you know what I mean, Scott. There's some judges out there that you just know are, prepackaged in a determinative way about their Indian policy and the interpretation. I don't know, and I haven't gotten a clear enough answer yet. And it probably needs to play out over a few years, huh, Scott, to see if we subject more administrative decisions to court review now, whether that'll break more favorably towards tribes. But
yeah, this certainly,
yeah, go ahead.
yeah, this certainly vests more authority in the court in terms of being able to say, well, I can completely disregard what the agency did. I think this is the right interpretation of the statute. Um, and when you look, it's a much broader issue than just the Chevron case. Is the massive amount of appointments that the Trump administration got through. I imagine that we have viewers on both sides of the political lines, but um, uh, how this selection comes out is going to have a great influence on whether we're going to see a lot more of the Eileen Cannons of the world, or judges that are more tempered and appropriate. Don't impose their personal views and their personal wills on the outcome of the case. So I guess that's my pitch to vote for Kamala Harris. Make sure that we try to if we have a crazy judiciary, the lack of Chevron deference will embolden those judges that believe that they can usurp both the authority of the administrative and congressional branch.
And moving forward, Scott, I mean, are there existing regulations? What is the statute of limitations here on challenging administrative actions from however many years ago now that Chevron defense is knocked down?
Well, that's one of the, it'll be interesting to see how this plays out, but that is one of the concerns. The APA traditionally, the 706 claims have a 6-year statute of limitations. And another case decided by the Supreme Court, I think the week before Loper, suggests that 6 years doesn't even begin to run until the plaintiff is actually impacted by the federal action. And the frustration that existed before Chevron, but is certainly enhanced by the Loper decision, is that tribes that do get favorable rulings out of the department and undergo very significant capital investments and devotion of resources in reliance upon that decision, where 5 years and 11 months later down the line, suddenly somebody files an action challenging the decision on which you relied, and that's a bigger concern now.
Mm-hmm. Right.
Hey, Scott. So, and Jason, let's go with you. What about when, there was a time when, Indian country did not had a relationship with the NIGC. And now, we've had a pretty good relationship for the last, 8 years or something. Does that have a potential to affect that in future NIGC regs?
Yeah, Scott,
sure.
Just evaluating it from there's an independent agency, and there's other independent agencies. What's the interplay now between tribes and their regulatory body there at NIGC?
Well, it's certainly an example where Chevron the loss of Chevron deference alters the playing field. As Victor pointed out, the tribes have had a very good relationship with the NIGC for several years now, and we have a comprehensive set of regulations promulgated by them. All interpretations of IGRA, even the the Alaska gaming decision that Victor referenced earlier, that was in the context of the NIGC approving the tribe's gaming ordinance. All those decisions now, are, I mean, they were subject to challenge before or after Loper, but the deference given to the NIGC's interpretation, is gone. And we can no longer defend those actions by simply arguing that their interpretation was reasonable, whether or not they were right or wrong or consistent with congressional intent. Now we're going to have to meet that burden. But I remember the days of Tony Hope. I remember, the NIGC as it first came out, wrote regulations that quite frankly, were irresponsible. They were like, how do we minimize the amount of work that we have to do to conduct our oversight of Indian gaming? And they're, I mean, most of those regulations are now off the books, but not having, if we have another Tony Hope NIGC, sometime in the next 10 or 15 years, we'll probably be gratified that we don't have to deal with Chevron deference in challenging those decisions.
Yeah, if we have any litigators or other attorneys or anybody who just wants to ask a question about Chevron, please do. I noticed, a couple of folks are saying, not all judges are bad and not all Trump judges would be bad, and we agree with that. There was a time, Robert Bork, he didn't make it on the court and he had some extreme policy views, but he was such a strict constructionist that he couldn't help but just, respect tribal sovereignty because it's written all over the Constitution and he reads it strictly and and there it is. Why that doesn't sink in with Alito and Thomas, I don't know. And Kavanaugh's got this weird notion that tribes are part of the state, but Gorsuch is good. So
yeah. To your viewer's point, Gorsuch is a Trump appointee, and he may very well be the most objective, knowledgeable Supreme Court justice as it relates to Indian law matters that we've seen, in decades. And if we had a court full of Gorsuches, I'd feel, pretty confident. Despite this conservative Supreme Court, the tribes have done pretty well with it, including the San Carlos decision this session and the denial of cert in West Flagler. But if you look at Justice Kavanaugh's analysis in the Castro Huerta case, that should be a red flag to all of Indian country. That right. here's a man that has no qualms about delving into revisionist history to justify his result. And when I say that the loss of Chevron deference reinforces and gives new vigor to the Indian canons of construction, well, that's only true as long as we have the Indian canons of construction. And I fear that those Justice Kavanaugh and others with similar philosophies would like to pare down the Indian canons of construction as well.
Mm-hmm.
Well, Scott, and that's what we see, case after case, it'll chip away, looking at, look at Maverick, at their attempt at trying to take a Supreme Court, case to the Supreme Court to chip away at tribal sovereignty. So this is an everyday, something we've lived with for a long time, right, Scott? This is when we go to sleep, we wake up. And, I've always said Pechanga.net has always been successful because everybody wakes up. I wake up in the morning just like everybody else and we go, okay, oh my God, what have they done today? That's kind of my job, is to figure out what's happening. So, I think the Chevron doctrine, I think there's it's interesting for me. In my layman hat, I see this stuff like.
No, we
I
lost
think we just lost Victor.
Yeah, but I'll pick up what he was saying. I think for a lot of folks, Scott, it's going to be difficult to, especially tribes, and when they're doing their day-to-day work, they're not going to be thinking about, hey, how is this law being drafted down in Congress right now, whether it's, an appropriations law or something along those lines. And that's going to be on, IGA and NCAI to really start to get in there again and be a little more specific on tribal language in any bill, to be honest, because we saw that during COVID and the COVID relief funds. We had to get in there and be specific about, tribal governments receiving the money directly and, not through a third party government entity. And so, those are the kind of things, Scott, that if anywhere tribes are going to put their resources, start thinking ahead now and not reacting to negative administrative decisions. And also moving forward, Scott, I do wonder, when the regulations themselves are being drafted and proposed, is that an opportunity? I mean, you got to wait till final agency action, but I think there's an opportunity for tribes to get in there and maybe incorporate those Indian canons of construction in regulations.
Well, I think that's right, and I do believe that their trust responsibility obligates them, when they're interpreting statutes, to apply those canons. But the fact of the matter now is those regulations are more prone to being challenged. And just like the development of a record as you pass legislation, the development of the record, and particularly as it translates into the comment period and the response to those comments and the way those are put forward in the Federal Register, I think becomes more important as well, because it's no longer going to be, well, as long as we're reasonable, we don't have to work any harder than showing that it's a reasonable interpretation. Now you need to help create the record, during the rulemaking stage, that the language that you're advocating for is consistent with congressional intent.
Mm-hmm. I mean, and one more general question, Scott, and if we don't have too many other questions here, might wrap it up with this. But generally, Scott, there's this feeling, at least among, whether you call it the right wing or whatever, that the bureaucracy is too large and unmanageable, that, you have bureaucrats run amok, that, in a sense, this deep state and all this kind of stuff. You can just look at the way they were questioning this poor acting Secret Service guy yesterday. It was like, they were looking for blame and not, causes. It was just, they wanted names and why hasn't anyone been fired? It was actually kind of frightening. It looked like something out of a Stalinist court or something, where you really don't care what the facts are. It's just, we want heads to roll. In your experience, first of all, have you found like bureaucrats to be openly hostile or openly ideological? Just in your experience. Sure. Okay. Yeah.
I mean, most aren't, but some are quite clear.
Right.
And over a beer, I'll give you names. But
oh, you got the names. Okay.
But to your point, I've captioned, I've framed my views, and I think there's some really good other materials out there. Jenner Block wrote an excellent piece on the impact of Chevron on Indian country. Matt Fletcher has been quoted in a number of articles as well. And I think my views are pretty much in line with theirs. as Chevron deference relates specifically to, Indian country and what the history has been in litigation as it relates to Indian country, et cetera. When you look beyond Indian country, because the Indian canon construction is helped temper what that body of case law has been in the context of Indian country. When you look outside of Indian country, both Justice Kagan and Justice Jackson, raised serious concerns that to which I don't, and I share the fears that, when you're dealing with specific federal agencies and you're dealing with the civil service, you have, career scientists and career policy people that truly know and understand the specific industry or industries that they're exercising their duties in terms of carrying out congressional intent, and judges don't have that level of expertise and industry knowledge, and the lack of Chevron deference does raise the prospects that a federal judge will just simply substitute his or her less knowledgeable understanding and make that the law, because he or she now can just simply disregard what the agency experts say as it relates to interpretations of ambiguities in the statute. Again, I don't want to overstate it. Deference to the agencies for factual determinations remain. Skidmore deference in terms of still providing respect. A plaintiff's lawyer is still going to have to convince a judge that the agency's interpretation was wrong, but he's no longer hindered with the much lower bar of the agency being able to defend its position as merely being reasonable, whether or not it's actually correct.
Right. Yeah. Right. Well, I mean, that's why elections are important, and it's kind of a weird situation we find ourselves in right now, with all the existing agency heads and political appointees right underneath them. They're all pretty much lame ducks, and all pretty much whoever wins this election is going to clean house and put their folks in, and I think it's going to be interesting next year. Whoever wins, I think with no Chevron defense, we'll find out whose fears are most correct in terms of because Scott, just think about it. Just in the past 2 years alone, all the climate energy regulations, stuff that the Department of Energy has been putting out about pipelines and coal factories. I mean, without this Chevron, we'll see what the future holds. But there's a lot of, and that's, I think, what the fear is. You can't, every time an administration changes, have a whole new wave of lawsuits challenging what they did the previous 4 or 8 years, right? I mean, that's the practicality of governing.
Right. That problem existed before Chevron deference. It's enhanced by the removal of Chevron deference.
Right. Well, I mean, Scott, we're going to keep looking at this as we move forward into the fall. We've got some big conferences coming up, whether it's it's an appropriate topic, even at the G2E conference, with all the stuff we're trying to get accomplished. Some of these gaming regulations are exactly that, like the slot tax, that's not a law. That's something that the IRS put in there, in a regulation back in the 70s. So this does impact our industry commercial and tribal. And I think it's a new frontier here. And it's funny, you said you went to law school and Chevron hadn't been decided yet, but I went to law school 97 to 2000. And when you take administrative law, it's like the first third of it is you're just, philosophical understanding of Chevron and all the different ways it could be interpreted. And, it was a main core subject, if you will, by that time in law school. So it's just crazy that they're just tossing out, decades old precedent like it was, never there, and that they think everything will just I don't know what, just proceed on some happy route here. But so far so good, right? I mean, nation's hanging.
Well,
so
yeah, for Indian country, it's frankly been far better than my expectations with this court. But
right.
With the exception of Castro Huerta, which I think is one of the worst decisions to ever be, worst Indian law decisions to ever be published. But in the broader aspect, the decisions of this court, have fundamentally changed, basic
right.
human rights and the structure of our government, although the overturning of Chevron deference is just a small piece of their larger agenda, I don't want my views that overturning Chevron may not be that big of a deal as it relates to Indian country. I don't want those views to be misunderstood, that I think that overall this group of justices are extremely dangerous to
right.
to our future.
Right. Well, I appreciate it, Scott. And we're going to pick this up again, whether it's at our mid-year at Tulalip in September 16th or the last week in October, the week before the election at NCAI. They're out in Las Vegas this year. So, we'll rely on you and our other litigators. We'd love to get you and Joe Webster on a panel somewhere as well to discuss all the latest out there for Indian country. But thank you again, Scott, for taking the time out to, come and talk to us. It's really important to us. And right now is a good time to talk about these kind of issues because Congress is wrapped up for the year. We can't, they're not going to get anything done. They can't even get spending bills done for 2025. For the federal government fiscal year ends in September. Yeah, it's going to be another mess. So do a continuing resolution until after the election, but we'll be right back in the mess again of, we'll see what the government looks like after November 5th. And hopefully everyone will agree with the results and, we won't have to evacuate the NIGA building again. So, but,
I just,
so anyway, that's it, Victor.
And by the way, yeah.
Go ahead.
Yeah, before I drop out again, Paula Hart will be talking about that at G2E. And next week, we will be talking about the election. We're bringing Ernie and bringing a couple other people to talk election too. And again, I apologize about my trouble service today. It's beyond my control, but I'm hanging in there and I appreciate you, Scott. This was a great conversation. Jason, thank you so much.
No problem.
Both of you, and for all the people who hung around, and it was a fascinating conversation. I think the way I see it, we need to be concerned on the new rules and regs forward, especially for online gaming. So I think that's where a lot of challenges for people who don't want the tribes to be online. So again, Scott, thank you very much. Jason, my brother, great show again. Spectrum, I hate you guys. Internet access, I don't like them. But I appreciate everybody else who showed up. Thank you guys so much. We'll see you guys next week. Bye-bye.
Excellent. Thank you again, Scott.
Thanks.
Take care.
Thanks.